COVID times. Ian Hull here, and we've got Suzana and Jordy hopefully online. Uh,
Hi, Ian.
hey, Jordy.
Suzana. Hi, everyone.
Um, so, if we could just, as we like to do at the start, announce everyone take their video off and their mute off so that we can keep the internet channel clear. Uh, we want to start this week with a couple of announcements and reminders. So we're on a bit of a tear next week. We wanted to just let people know that there's some other options as well. We're going to be doing, of course, week 15 of our webinar on Friday morning at 8:30 at our regular time. We're also going to be, Jordy and I are actually going to be co-hosting with Duff and Phelps um, a seminar. It's an hour-long seminar on estate freezes, and that's going to be held on June 25th. That's Thursday from 10 a.m. till 11 a.m. We'll put these announcements on our webinar announcement that we send out weekly, but we want to let you know. And I'm actually going to be a guest panel speaker on Wednesday at 7 p.m. on a what's called a virtual fireside chat, and we're going to be talking about challenges facing the legal industry. So lots coming up next week, but we've got an action-packed day today, so we want to get on with our topics. What I wanted to start with is just talking a little bit about some of the resources that we have that we're going to focus on. I'm just going to share my screen. Um, we're going to talk a little bit about the accounting obligations because Suzanne and I and Jordy keep running into the issue of we create these fantastic documents and then our clients haven't really got a full understanding of their obligations. So I just wanted to highlight for a moment the resources that, because we're going to go through some of these topics, but some of the resources that we're relying on here in terms of our discussion. And for example, I encourage you, if you're interested, the resources page of our blog, our webpage, sets out various areas of resources, and of course, they've got search items that we can have. The key that I wanted to highlight today was the slide shares, and the slide shares themselves are a tool that are available, and please use them as you see fit. You can use whatever aspect of them you like. Today we're talking about some accounting obligations at the beginning of this seminar, and but you can see the tools that are available. And the one tool that I like for the starting our topic here today is if we're going to create the power of attorney document, maybe there's some content that you can use here to help you with your discussions with the client at the intake level, and maybe even for your reporting letter. So this slide share that we prepared, and this is just one of the many slide shares that are on the web page, gives you some content that may or may not be helpful, but it really does cover off what we think are the essential reading components of power of attorney, but it also may be a resource. You could create your own, forward it on to the client, include some of this in your reporting letter in a standard format. So I just wanted to make sure that people knew that these slide shares were available. And as I say, we've covered almost every topic. We're always building it out, but almost every topic in the area. And it really does give people an opportunity to give a resource to the clients on questions of basic estate administration questions like this. So we've got compensation, for example, and some of the content there might be of help to you. The other element of the resource I just wanted to briefly identify was, of course, I can't find it, but oh, that's really good. I'm going to get back out of this, and how do I stop slide sharing? No, that's not going to help me. Just a sec. Got to get out of my slide share. So the resources are available. So when we talk about some of these things, please feel free to go into our webpage and sort of noodle around, look at the resources, and it's all keyword searched. So that having been said, we've got often at the end of these seminars, we get notes from people saying, you know, what precedents you're working from or what materials you're working from, and a lot of it is on the webpage itself. So Jordy and Suzana, let's start with you, Suzana, if we could. I just want to dive into some of the initial advice we're going to give our clients when they are appointing an executor or an attorney for personal care in respect of their accounting obligations, and what kind of initial options are we trying to help identify with?
So I think when we're talking about possible people who could be appointed to those positions, we want to have the kinds of discussions we talked about a little bit last week in terms of the suitability of the candidate for the position, their responsibilities ultimately, and to whom they have to ultimately also account. And the accounting obligation is one of the highest of the fiduciary obligations that these individuals have. And many people, when they take on the role of an attorney or an estate trustee or even a guardian, don't necessarily know the requirement to do so. And so there really is a distinction between, the discussions when we're actually looking to appoint someone in this fiduciary capacity and when we're actually providing advice to the fiduciary, him or herself, when they're taking on the role that they are, whether it be an estate trustee or an attorney.
All right, and just one of the things I like to use as a tool, and I'm just going to share my screen again to kind of highlight this point, but also maybe shock the client into the reality of some of the obligations, is I'll pull out a sample set of accounts and I'll say to them, look, this is the kind of format accounting obligation that you may be faced with in respect of your duties as attorney. And when you put a document like this with them, and I may not take time to go through the concepts for sure, but you put a document like this to them and you show to them that these are the kinds of expectations. Every single transaction is going to have to be tracked. I like to make sure that that helps inform the client in making their decision as to who they're going to appoint. So that's just another tool that I use as a starting point in getting the advice and giving the advice. All right, so Jordy, over to you in terms of some of the accounting obligations issues that you'll cover when you're taking in the information to appoint fiduciaries. Okay, we can't hear you.
I got this fancy mic. Can you hear me now? Good morning. Good morning. Clients often ask, so what does an executor do? What does a trustee do? And so this obligation to account, I always say that they're going to work for the beneficiaries and they're going to be accountable to the beneficiaries. And who are they going to have to account to? And the level of, responsibility. And so if you're, when you're picking an executor, if you've got somebody who's just, keeps everything in a shoebox and that's their sort of personality, that might not be, unless you sort of explain to the client that they're going to have to go out and hire somebody to make sure that they can do this, because this is a big responsibility. And like you do, excuse me, the idea of showing them and this is important as well when the client comes into the estate trustee comes into your office and you start getting them ready for their job. This is what it's going to look like, and clients are shocked at the level of detail and particular requirements for accounting. And so it's just to inform clients, because if they've never done it, they have no idea of the obligations as far as accounting goes.
And one of the tools, and I like to go a bit extreme and then I bring it back, and I personally do all of the accounting for my mother-in-law, for example, and I have literally a spreadsheet that I just identify the expense, the amount, the person, and I send it out to all of my siblings, not my siblings, my mother-in-law, so it's all the other side. So I'm even further distant from it. Well, my siblings probably hate me more than my in-laws. But the idea is that I will send out, and I do it once a month. I just say, here's what we spent this month. And then I always send out the bank statement that comes in. It's all on email. Send the bank statement, and I send my list of expenses that have come out. And I always say, any questions, let me know. Now, it's not the be all and end all, but they're appreciative. They see where it's going if they want to look. And it's a tool that it's sort of the other extreme. And that is that at least I say to my clients, just keep the information flowing. And then you're going to find that you're going to take some of the edge off of what is potentially some tension. And I also, what I do is annually, as I go, okay, this is how much we've got left. Budget when we run out. If she lives to 160, we're going to be spending the money in 2 weeks. So that kind of idea. And so I'll give them an annual sort of summary. This is approximately what we spent this year. This is approximately how much we've got left. So those are just little nuggets that I give to my clients to say it's not that you have to be a CPA or something. You just need to be someone who is efficiently and transparently dealing with the money. And those are some of the things I say. Suzana, you're on mute.
Thank you. That transparency, and I think, is the key when we look at it from a litigation perspective and all the possible difficulties that executors can face at the end of the day. Having an arrogant or a secretive executor is one of the easiest ways to bring upon litigation. And so to the extent that you're sharing this information and doing it in a timely fashion or relatively frequent fashion, I think goes a long way to avoiding a lot of fights, because you'll know at that point in time, if anyone's going to complain, you can address the issue in real time, so to speak, rather than have to deal with it maybe even years later and try to recreate the vouchers or the explanation for any particular transaction. So having that transparency, again, really key in order to avoid fights, I think, in the future.
Jordy, do you have anything else to add on this topic?
Well, yeah, just the idea, if we're at the stage where the estate trustee has come in to retain us, I am a big believer in getting the estate accounting in court format from the very beginning. And the reason being, I want to be able to say to, especially if you've got beneficiaries who may be difficult, I don't want to negotiate with beneficiaries about what I've done or what I haven't done. So if I have everything in court format and I send it to the beneficiaries when it's time for release, and they start saying, well, we don't like your release, and we don't like you did this, and we don't like that you did that, and it adds up to like a $3,000 or something, of objections. I'm like, no problem. I'll just pass my accounts. And now we know, as people on the inside, lawyers, we know what goes into court form accounts. So if I'm sitting there just with a spreadsheet and I've given you summaries, to try to put that into court format, that's going to be a big expense and a big time issue. But if they're all ready to go, as the executor, I'm just like, no problem. Don't sign my release. I'll go past the accounts. And guess what? I'm getting my costs from the estate, and it's so go to town. Knowing that I've got those accounts ready to go and issue the application, there's no bet. I mean, I just that puts the ball in their court, and you have control as the estate trustee to say, no problem. I don't really want to fight you about whether I should have spent that, the $500 on this or spent, that. Let's go and you bring that to a judge and see how a judge feels about it. So that's why I would encourage my clients to get things in court format right from the beginning. It's way easier. The amount of time spent, trying to recreate, as Suzana has said, very difficult.
Yeah, that's great leverage for sure.
And I think one of the things that's law, but it's good law still, and that is that, of course, a fiduciary has to have their accounts on hand and in hand, and so to speak. And judges give lots of leeway and timing for accounts because people are scrambling at that point. But boy, it's a nice piece of, as Suzana says, levers when you say, got them, here you go. Unfortunately, in this COVID time, it's not quite so easy to get these accounts passed, but those days will come. Okay, that's great. Well, we just wanted to spend a few minutes about that sort of substantive issue. We're going to actually identify some accounting issues as we go along in our webinars, and we'll probably segregate at least one full seminar on accounting issues coming up shortly. But we wanted to highlight it, and that's a trailer or whatever, a teaser. I don't see on net. Okay, so let's go back to drafting issues. Jordy, if we could start with you. especially in respect of spousal trusts. And I guess where I worry the most about spousal trusts is, of course, the issue of tainting. And maybe, Suzana, you can just describe the legal issue, the tainting issue, and then Jordy, you can just give some of your comments on spousal trust drafting from your perspective and some of the tools that you're using to avoid the horrible results of tainting. So, Suzana, do you mind just talking a little bit about the concept of tainting?
Sure. On a very high level, what we're doing when we're creating a spousal trust is basically deferring the deemed tax that would arise on death until the life of the surviving spouse, and until the death of the surviving spouse, sorry. So there's a delay there, so the tax doesn't have to be paid on the death of the first testator, but on the death of the spouse. And the whole planning process is oftentimes focused on avoiding this tax or at least delaying it. And in order to do so, we create these spousal trusts where the spouse is entitled to the entire income entitlement and the capital entitlement during their lifetime. So no one else can have a right to either the income or the capital of the trust during that spouse's lifetime in order to avoid it being tainted. And the tainting, once it is tainted, is once it becomes taxable. And, you know, a lot of fancy steps are taken to avoid that consequence because it can have quite a devastating one on the estate and particularly on the spouse.
So, Jordy, maybe you can give us some of your introductory thoughts on the deferral of spousal trusts.
So just to talk a little bit about the use of them in and what sort of circumstances. So the idea, as I always describe it, is you know, surviving spouse, your spouse survives. You've got two options here for providing for the spouse. One is an absolute gift, which means that that spouse will be free to do whatever he or she wants with that inheritance after they inherit it, including changing their will and giving it to somebody that you hate, is the way I usually put it. So that's option one. And then the other way is, of course, using a trust. And the way I always identify that for a client is saying, did you use the word but? So if you say, I want to give it to my, yes, of course I want to give it to my spouse, but I want my kids to get it at the end. So as soon as they say that, they've just identified that they're looking to do a trust if they really want that, if that's very important to them and they want to legally bind the spouse to that. So that's how we identify whether a client is wanting a spousal trust or not. And then we go into the different ramifications of that on a more technical basis, which I'm happy to take you through whenever you're ready.
Let's talk about just a moment. Now, the tool of spousal trust, though, I think is underutilized in some respects in second marriages. And I just wanted to know what your thoughts are in terms of the advice you might give clients who are in a second marriage situation using a planning tool of spousal trusts.
So what I would say, and that's a more common scenario for when you would use spousal trust as a blended family, where obviously your client has kids from one relationship, the spouse might have kids from another relationship, or not share the same kids. So, you know, clients often say this, oh, I want an absolute gift. Yes, I want everything to go to my spouse. And they're all on board. And then they say, but I, you know, of course, when they die, it's going to go to my kids, right? And I'm like, hold on, remember what we said about those two choices? And it's funny, it's simple, but it's hard sometimes to get people's heads around that. Is, you know, I catch them. I said, no, remember, oh, did you use the what but there? And so you say, no, remember, it's either there's no strings at all, which means that it's going to go to some other person. Assume it's going to go to some other person that you don't like. Or we've got to put this but in. And that's really the only two choices you have. The third option outside the will, of course, is a domestic contract that can work or not. But yeah, you were describing a spousal trust when you say, I want it eventually to go to my kids. And they say, but I don't want a trust. I don't want anything fancy. I want a simple, you know, okay. But, you know, and I think at some point I pulled up my little planning slide. Maybe I'll just do that just quickly here. I don't want to take up too much time, but
We got the, don't worry.
okay. So just in case I haven't shown this, this is what I share with the client almost every time, just to make sure they don't want this. But this is the spousal trust, right? And I say, okay, so the income that's generated, you're going to take whatever asset you want to provide for the spouse, your $1 million or your whole estate or your house or whatever it is. That's going to be here, the principal, and then the income that's generated on that. Let's just say it's $1 million. The 50 grand that's generated, that's going to go to the spouse with no strings, and the spouse doesn't even have to ask for that, and they're going to get that. And then you're going to make up the rules here about how other money is going to go to the spouse. And that's really the key to a spousal trust, is that you've got the spouse getting the income. You're going to have a trustee up here. And I wouldn't start talking about the trustee, quite frankly, until you've figured out what the rules are for withdrawals. So just to show.
Screen sharing this?
Yes, I am, but not with you. No, I'm just kidding. That would help if I screen share.
Well, I'm looking at thinking, he thinks we actually see something here.
Yeah, so you are listening. I'm just wondering why it took you so long to respond, Ian.
Well, because I can't get a word in edgewise.
Okay, that's it. No, that's good. You're quite right, actually. So this is the slide that I share with the clients, and I talk about how whatever you're going to put into that spousal trust that you want to protect for your children at the end, it goes in here. The income is automatically, as Suzanna's pointed out, that's how we're going to defer the trigger of capital gains. The income going to the spouse with no strings, but then the withdrawal of the capital and setting up the rules for what rules are we going to have for the withdrawal of the principal. And so I break it down into mandatory payments. Well, we're going to have the income for sure, but maybe you want to provide for a minimum annual amount to the spouse every year from capital. That's a mandatory payment. Maybe you want to leave discretion to the trustee and sort of unlimited discretion. And that's going to fit in. So the decision here is going to fit into the choice of who the trustee is going to be. Because if you leave the trustee with unlimited discretion to use capital for the spouse, then you might not want the spouse as the sole trustee, because I've never had a spouse who asked themselves, can I take money out? And they said, no. It's never happened. So if a spouse is going to be the sole trustee, they're probably going to be able to take out whatever they want. And so that might figure into the decision making there. And then the other set of withdrawal rules might be some sort of limited withdrawal. So limited to certain amount of principal, limited to specific purpose, limited depending on events like remarriage or cohabitation, or the spouse using up their own assets. And maybe, Suzana, do you want to or Ian, just address the idea of capital and the limits on that? Or
that's a great idea. Maybe over to you, Suzana, just the distinction between capital and income and that breakdown.
Oh, sure. So the capital is the amount of money that is ultimately settled into the trust. So how much there is in the trust, and the income is the income that is generated on the capital during the course of the lifetime of the trust. And so in order to have a qualifying spousal trust, without giving any tax advice, because of course I have no tax expertise, but my limited understanding of that is that as long as all of the income is paid annually to the spouse, all of it, and the capital ultimately only used for the benefit of the spouse, then you'll be able to preserve these capital gains planning mechanisms that are in place to defer the tax until the death of the surviving spouse. So the capital is the actual basis of the trust, the corpus from law school days, and the income is what is generated by that capital.
Jordy, or Suzana, we'll start with you, Jordy. We're asked if assets are all joint, can you have the spouses jointly contribute to a joint partner trust and then set up a spouse trust within the joint partner trust?
So the first thing I say is I don't do inter vivos planning like that, but I believe that if that you can contribute to a joint partner trust and then set up spousal trust rules about how it's going to work when one of the partners dies. So I think that's planning that you could accomplish. Again, inter-vivos trusts have their own issues, and you'd want to get tax advice. It makes their life a little more complicated as well. But it is a way to create a joint plan, potentially, that can deal with, how things are going to flow when both spouses are gone.
Okay, and just staying in the spousal trust world here for a moment, Jordy, just following up on your blended family scenario, how do you deal with the clients who come to see you they're in a second marriage and they want mutual wills and the like? How do you sort of stick handle that request?
Well, the first thing is this whole idea of mutual wills, meaning that they're bound not to alter it after the death of the first spouse, causes a whole bunch of problems. I would first of all, I wouldn't do them, but I would strongly recommend that the client not choose that method of trying to, it's a simple solution to an extremely complicated situation, because really what they're describing there is a trust. I mean, they're saying you're going to get what I give you, and then you're bound to hold it in trust and distribute it in your will, similar to mine. That is, in essence, a trust. The problem, of course, is there aren't rules. A properly drafted trust considers all of these issues, whereas a mutual will really doesn't. It's like a sledgehammer kind of solution to something that really needs tweezers to sort of work out, because there are all kinds of issues, like with an inheritance. Let's say you take a mutual will, you use a mutual will, which means the first spouse dies, leaves the second spouse $1 million. Okay, the second spouse, under this mutual will, is bound not to change their will. Oh, that's all great and fine. What does that mean that the spouse can do during their lifetime? Can they spend any of that $1 million? How much can they spend? Can they only spend on themselves? Can they gift? What about after acquired assets? So the first spouse dies, they inherit the $1 million. Then they go on with their life and they marry for a second time, or they have a relationship and they inherit more money from this other spouse or this other person, or they win the lottery or something. Are they bound to leave that to the children of the first spouse, for example, under the mutual will? There's all kinds of, issues about after acquired property, spending during the lifetime of the second spouse, gifting. All those things are not dealt with in a mutual will. A simple mutual will. What you probably need is a domestic contract that covers all of those issues, which I believe is what a mutual will agreement is. It is a domestic contract, in my view.
Suzana, did you have anything to add on the mutual wills scenarios?
Yeah, I totally echo Jordan's comments. I think that they're, oftentimes, at least from a litigation perspective, a recipe for disaster. We've seen so many fights over, those issues that Jordan identified, and other ones as well. And the interplay between a mutual will and a domestic contract can also be quite complicated. And it just leads to a whole bunch of difficulties that could be, and I've seen many times, avoided with just a properly drafted spousal trust, which gets the same result, but a lot cleaner and, at the end of the day, a lot safer, I think.
So finally, and maybe Suzana, I'll start with you. One of the things that not finally, because we're going to go to the technical issues next, Jordy, we're not leaving spousal trusts, just to give you a heads up. One of the things that Suzana, you see certainly when you're doing your defensive law pro work, if you have not put together a spousal trust, you have not gone through that option with the client, what are the sort of damages that are available? What I'm saying is this: first of all, what can we do to avoid that negligence claim? But secondly, the damages really tie to the deferral, and that's you can, smarter people than I can calculate the loss of the deferral, and they can also calculate, any administrative or additional professional fees that are incurred and so forth. So I guess from that standpoint, there's also a negligence piece that we need to protect ourselves in, not just in the drafting part, but with the actual reviewing this concept with clients, especially in a blended situation, but with even first marriage clients, to give them that option, to make sure they've been told about that option. I know, Suzana, I know have had to defend that case in the past.
Yeah, absolutely. And it's so much like the the primary and secondary will situation. These are discussions we have to have with our clients in terms of what may ultimately happen if we don't set up a spousal trust, or if it's not set up properly. Here's the tax consequences of it. And having that discussion with clients is very important, because they may still say, notwithstanding the fact that there is this mechanism by which we could try to defer the taxable capital gains, they may say, no, it's just too complicated. I don't want to spend extra legal fees on creating a trust. I just want a basic will, a simple will, and that's all I want. And, there are going to be clients who say that, absolutely. And we just want to make sure that we protect ourselves on the solicitor side by documenting that. So making sure that we're reporting on the fact that we've discussed it, that we in fact recommended it, but notwithstanding that advice and those discussions, the client has decided they want to pursue a simple will. And so we haven't included that. That's really going to be important at the end of the day when the beneficiaries go after the drafting solicitor saying, well, listen, had you just set up a proper spousal trust, all of these taxes could have been avoided, and there would have been a lot more money left into the residue of the estate for the beneficiaries. And so the solicitor in that case will be able to demonstrate and protect themselves against these kind of claims with their reporting letter, with their files, and with their notes otherwise, documenting the discussions and the decisions ultimately made by the testator not to include such a provision.
And I think that, the deferral piece is so, it's not complex planning. And so I think also the courts are going to be potentially frustrated if clients haven't, when they see a red flag, and this comes back to Jordy, certainly in your asset intake work, because you're doing your asset intake and you can identify some serious tax liability that is going to hit on the death of the first spouse. And I know your own tool that, the estate planner shows the kind of taxes that may be payable. And, if you've done that and you've showed the client this, and you say, okay, look, you got to fund $1 million in tax. Easy illustration is your portfolio or your cottage. And it's in your name alone. It's going to be your tax. Your wife, your surviving spouse, is going to have to come up with $1 million within 18 months of death. How's that going to work? And those are kinds of things that, by carefully looking at the assets, and clients resist asking about assets sometimes, but I always push back and say, well, look, that's fine. Then, I can't give you advice in the context of that, and I can't give you some direction as to what kind of planning tools that might be available. But if you've got some obvious red flags and you haven't raised it, I always get nervous. That's all. And I think, Suzana, that's good advice in terms of documenting it. Jordy, before we go to the technical point, can we just got a question on the chat? Is how do you deal with property held as joint tenants in the context of this preparation of or considering spousal trust planning?
So I'm just going to share my screen just to show how I might deal with this. So the way I always describe, joint ownership is that if two people own something jointly and one dies, they literally just fall off title so that the other one is owning it. Well, you can't give away your half of a jointly owned property. So as soon as they start saying, well, yes, we own it jointly, we own the family home jointly, but I want my half to go to my kids, then we can't own it jointly, because a joint ownership is a mini will. And so you have to change that mini will if you don't want it to go to the surviving spouse. Absolutely. So the way to deal with that is obviously to sever the joint tenancy and create a tenancy in common. So now I can give away my half of the home because, or you live with the expectation. In this case, you've got, Ben Collins and Lauren Collins. They own the family home jointly. I say, if you die first, Ben, assume that Lauren is going to move into that house with her new spouse and give it to him when she dies, because that's what is possible with a joint ownership. And if you're willing to live with that risk, then leave it the way it is, or else we'd have to change the way you own it. Because if you own it jointly, you can't say but. You can't use a but with the joint ownership. So that's how I would deal with that.
I think that it's also your illustration there where you've got the income tax in red. That's a red flag, so to speak, and it gives you an opportunity to say, do you want to do planning around that? Not that we need to give detailed tax advice, but do you want to do planning in the context of that income tax? And then the probate tax is the other obvious planning step that you want to consider. And your tool gets it right on the front end. But I just want to just follow that up just before we. So you go ahead, Jordan. I got another question.
Yeah, just so in this kind of situation, once we've talked to the client about this option of a spousal trust, they say, yes, I want to protect that money. I've got $1.6 million left. I want that to end up going to my kids to the extent after my wife is looked after. So I say, okay, you used a but, right? So we're going to use a spousal trust. So we can just create this spousal trust, and that will show that the income tax is eliminated as long as we do the spousal trust correctly. But let's say, so the advantage is we know that we've done this trust correctly because the income tax is zero. Then the client says, well, hold on a second. I want the money. I don't want my spouse getting all of the income if she remarries. So you go in there and you say, okay, payment of income, I want it to terminate on remarriage, for example. You say, fine, no problem. The only downside is that $250,000 of tax is going to come back because this is no longer a qualifying spousal trust. So software can alert you to the fact that, here it says, it's a warning, the trust that you just set up for Lauren is non-qualifying because the income is suspended or terminated during the spouse's lifetime. So what I would always do, if say the client says, yeah, no, I understand that, but that is very important to me, I would then make sure that's well documented and even have the client sign that they've instructed me to do a non-qualifying spousal trust here. Okay? Because no doubt, Suzana, I'm sure you've seen this before, when the lawsuit comes and the tax has been triggered and all of a sudden they're looking to the lawyer and saying, you screwed up. You should have, you created a trust that wasn't qualifying. You tainted the trust. And the lawyer says, well, but those were my instructions. I went over it with them. You'd want to have, there's going to be a presumption that there was an error there unless there's some good evidence that it was intentional.
Oh, absolutely.
Jordy, go ahead. Go, Suzana.
I was just, I'm good.
Okay, so Jordy, one of the questions come up, and maybe we can just reconcile this. How do we reconcile the ability, spousal rollover? We're not giving tax advice here, but the concept of spousal rollover generally exists in certain assets with regard to the Income Tax Act. Because clients come in and they presume that everyone's going to flow to my wife or my husband, on death. The income taxes, they don't touch me. How do we reconcile that with the spousal trust planning?
Well, if done properly, you'll get that same deferral, right? That's what, if you're using a qualifying spousal trust that, as Suzana has pointed out, all of the income is going to the spouse for the entire lifetime of the spouse, and no one except the spouse has access to the capital during the spouse's lifetime, then you're going to defer that income tax until those assets are sold or whatever, or until the second spouse dies. So, that is the way to reconcile putting strings on it, having a but here, but still getting the advantage of the income tax. It's not wrong for a client to say, look, this is just a deferral. This doesn't eliminate income tax, right? It just defers it until the second spouse dies. It may be that the true intention, the true wishes of the client are, I want my kids to get the money right now. I don't care that that some tax is going to have to be triggered and paid. So it'll be paid, and it's going to be paid eventually. And the real issue is if there's no liquidity. It's fine if it's income tax that's triggered by stocks that are publicly, by publicly traded stocks. You can liquidate them, pay the tax, big deal. The big issue is is triggering income tax when you've got an illiquid asset like shares in a private company, perhaps minority shares, for example, or a cottage that you're trying to keep in the family. Those are things where you're going to trigger the tax if you don't use a spousal trust or some other rollover technique. And yet you want to keep that asset. So you're going to need some other kind of planning to come up with the liquidity necessary to pay the tax.
And so, but we know that under the Income Tax Act, certain assets just roll over to the surviving spouse in any event without the estate planning of a spousal trust. And do you have clients say to you, well, look, I'm just going to take whatever the Income Tax Act will give me to roll over, and I'm not going to bother getting into this whole planning level?
Well, I mean, it's got to go to the spouse for the income tax. So, for example, an RSP here for $100,000. If let me just get rid of this spousal trust to demonstrate this, but because it's going to not. So, we've got $300,000 of income tax here. Obviously, an RSP going to the spouse, there's going to be a rollover, and all of a sudden, we've just saved the client, 50 grand of income tax, just using. There's the spousal rollover for registered plans, and designating the beneficiary has the additional benefit of avoiding the probate tax on that as well. So that's how you can, obviously the Income Tax Act gives that ability to roll over registered plans.
Right. And that's the difference, right? I mean, that's the thing that I always find. I got to walk through the client and coming back to your first principles. If I don't know the nature and extent of your assets, I can't give you guidance and I can't tweak things to the extent of saving 50 grand. That's worth it if we can do it, if it makes sense for other reasons. And so when I get the resistance with clients who don't want to give me all the information, I say, fine, but you're just not going to get the full benefit of all of the ideas that I can put forward. All right, so Jordy, let's continue on with the discussion. I've just got a question here. If you recommend a client to set up a spousal trust, do you recommend that they meet with an accountant to have a better understanding of the tax filing requirements that their trustee will have to deal with in administering the spousal trust? Jordy, and then Suzana, maybe you can jump in on that one.
Right. So for every good idea, there's a whole bunch of problems. And, when I'm explaining to clients about the spousal trust, my reporting letter says a couple of things, disadvantages of the spousal trust. For the first thing is the tax filings that are required to do. And I'm not a tax person. I exclude tax from my retainer. But so the first thing is, yes, it's a trust. It's going to have filing return obligations. And I just put that in sort of broad terms. But the other big one that people don't necessarily recognize, and this ties back to the whole issue of accounting, right, is the obligation to account to the remainderman. And maybe you guys can talk about how that obligation arises and what that entails.
Yeah, Suzana, maybe you can just break down that, because it's the unknown obligations of accounting that clients don't necessarily understand, and the levels that it can go to, the depths it can go to.
Sure. In the spousal trust situation, of course, there's going to be a trustee, and that trustee is going to be administering the trust according to the terms, as sort of outlined here on Jordy's slide as an illustration of the kinds of terms. And so apart from actually having to file tax returns, they're going to have to keep trust accounts. And that harkens back to our discussion at the very outset, where the beneficiaries are going to hold the trustee accountable to demonstrate how the trust was administered during the course of the spouse's lifetime. So there'll be an obligation to show the income payments and the capital payments, to whom and for what purpose and at what point in time. And so the trustee is going to want to make sure that they're administering the trust in accordance with the terms, because when that accounting comes to light and has to be prepared, the remaindermen, the children, who are going to be entitled to what's left of the capital at the end of the day, may have questions and may have concerns about how that trust was administered and how certain funds were paid to the spouse during the course of his or her lifetime.
And when you say children, what does that involve from a substantive standpoint?
Depends, of course, on the nature of the children. If they're adults, then the adult children will be holding the trustees accountable. If there are minors involved at the end, then the Office of the Children's Lawyer could be involved, or if they're incapable beneficiaries, the Public Guardian Trustee's Office. So we're adding a layer of an additional set of eyes looking over these accounts and holding the trustee accountable.
You've got, of course, unborn and unascertained. So if you do a classic issue per serpes scenario, you're exposed to potentially at least 3 layers of review: the adult children, the minor children, and the unborn and unascertained, all of whom could be poking away at your good work.
Absolutely.
Jordy, if a spousal trust is being used in estate plans, do you also suggest a domestic agreement if there are family law concerns?
So anytime a spouse is not getting 100% of the estate, absolutely, there should be some concern about the fact that this plan might fall apart in the event of an election on death, because a spouse might say, look, rather than me getting drips and drabs of income every year and then relying on a trustee to give me more, I'll just take my equalization entitlement. And that would then collapse this trust. It would accelerate the rights of the beneficiary, the children, the remainderment, so that they would get their money right away. But the spouse would get this lump sum from the estate, absolute, with no strings. And if that's something that and the testator alone can't prevent that, right? That is a right that every spouse has to choose an equalization versus what's in the will, unless there's a domestic contract. So that might be a recommendation if the client is very concerned about this fact that the spouse could get a lump sum instead of the trust rights. Then a domestic contract probably is the only way to avoid that. But you need, obviously, a contract requires 2 willing participants, and that means that both have to agree to that.
And Suzana, can you talk about the enforceability of those contracts?
Sure. So certainly a claim against the estate for an equalization is one way to get around the testamentary planning or the intentions here. And in that case, the enforceability of the domestic contract is something that is certainly going to be taken into account by the courts. So if there is a contract, it is more likely than not that that contract is going to preclude this claim for equalization. But that same contract will have very different possible results in a dependence relief situation. So another way to get around the spousal trust is if the spouse were to say that that spousal trust entitlement is not sufficient for his or her lifetime going forward, and they make a claim for support in addition to what they get under the will. And in that case, the enforceability of a domestic contract or marriage contract is just a factor that the court may consider. So it's not necessarily going to preclude a claim for support. It's just one of the many factors set out in the SLRA that a court can take into consideration when determining whether or not adequate provision was made for the proper support of a dependent.
Excellent. All right, Jordy or Suzana, we're just getting closer to the time wrap-up time. Jordy, did you have any more technical comments you wanted to make with regard to the drafting issues in respect of spousal trusts? You're on mute.
I was saying, Ian, that you got me, that you made me get this fancy mic, and now I can mute.
I appreciate it. It's way better.
There are some, but I think maybe we can, just because it's probably a more lengthy discussion about the more technical things, I think we should maybe defer that, if that's okay.
Yeah, and that's fine. I was going to say what I'd like to do, starting with our next week's seminar, is to roll our sleeves up and talk a little bit about some of the technical language and some of the issues that are going to arise drafting spousal trusts. So if there's any other high-level comments and there are no further questions, I think we'll wrap up for today's seminar. We'll be back next week. As I say, next week's a jam-full webinar week for us. We've got 3 webinars. The State Freeze Seminar webinar on June 25th between 10 a.m. and 11 a.m. with Duff and Phelps. We've got a webinar on practice issues and virtual fireside webinar. And then finally on Friday, we'll be back to our webinar for week 15. Just one last question. Has anybody run into, I've been asked, has anybody been able to probate a will that's printed on double-sided? Jordy, have you run into that at all? Will printed double-sided?
I have not. I don't see why you couldn't, but I haven't seen that.
Yeah, I agree. Intuitively, it doesn't make sense that you can't, but certainly years ago, I remember the government of Ontario was one of the first people that started to have printing on both sides when they sent a letter. Now it's not quite so important with most of our letters going by electronic, but I can't imagine if the government of Ontario is going to be the ones to get in the way of that. But good question, and if it turns out it's a problem, let us know. All right. Well, listen, thanks so much, Suzana. Thanks, Jordy, for a great week, and everyone enjoy your weekend, and we'll see everyone next week. Thanks a lot.
Thanks, everyone. Bye-bye.